Hey, don't forget, please subscribe and make sure you hit that thumbs up. Appreciate you guys. Hey, you beautiful tubers out there. How y'all doing? Let's do a little quickie here. We got a new federal court filing, right? This is document 81. Yeah, that's a lot of stuff, man. That's a lot of stuff's been put in. Anyway, United States District Court for the Northern District of Florida, Gainesville Division. Yes, I do know where this is. Yes, I understand all the things I've said before. No need to comment to tell me where it is. I know. Jeremy Hales, plaintiff versus John Cook, etc. Defendants order. So this means the court, the judge. He's not hungry. Okay. It's what he's ordering you to do. You, the parties involved. Presently before the court are plaintiffs' motions for summary judgment as to defendants' counterclaims and supporting memorandum, Doc 73, 74, 75, 76, 77. For the reasons below, the court will strike plaintiff's motion for summary judgment and supporting memorandum. That means everything that was filed on behalf of Hales was struck pertaining to the summary judgment. Summary judgment, memorandum of law, struck. It's gone. Not there. After the motion to dismiss was granted in part, in document 63, defendants answered plaintiff's complaint on February 8th, document 69 and 70. In their answers, defendants asserted 3 counterclaims against plaintiffs, including 1, intentional infliction of emotional distress, 2, unauthorized use of defendant's likeness under Florida Statute 540.08, and 3, common law invasion of privacy under unauthorized publication of defendant's likeness. Mere 3 days after defendants asserted their counterclaims, plaintiff filed motion for summary judgment and supporting memorandum, primarily arguing the defendant's counterclaims failed for lack of evidence. By the way, I just want to take this moment to show you that notice how the court is justified. Notice how their stuff's justified. How good it looks. It's compared to the stuff that's presented by attorneys. Let's see here. Nope. Excuse me. Counterclaims lack of evidence. The deadline to file dispositive motions in this case, including motions for summary judgment, is April 28th of 2025 this year. Yet both sides, plaintiff and defendants, have now filed summary judgment motions before the full development of a record as to the claims and counterclaims at issue. Y'all, we haven't even vetted everything out yet, and you're already doing summary judgment. Like, this is like premature. Wow. The court is concerned that both parties are filing early summary judgment motions with plans to file more summary judgment motions later in the litigation because it consumes substantial judicial and litigant resources early in the game. This piecemeal strategy of filing motions for summary judgment near the inception of the claims is highly disfavored. Y'all, you're picking and grabbing at stuff, and we don't like it. The court does not like this one bit. Knock it off. Well, they haven't said knock it off yet. There's so many beautiful words to get to first. See Millgate Development. The District of Alabama actually cleaned up. See also Allstate Financial Corporation v. Zimmerman in the 5th Circuit, which is unique to me that the 11th Circuit here is citing persuasive cases outside of the 11th District. We certainly do not approve in general the piecemeal consideration of successive motions for summary judgment, since defendants might well normally be held to the requirement that they present their strongest case for summary judgment when the matter is first raised. The footnote up here says the Fifth Circuit decisions issued on or before September 1981 are binding precedent in the 11th Circuit. Oh, so they broke up the circuits. You get that? It's a Fifth Circuit opinion that it was filed before September 30th of 1981. The 11th Circuit was still part of the Fifth Circuit. Congress decides how many circuits there are. Okay? Remember, the only court that's required, only constitutional court is the Supreme Court. So when I just said it's interesting that they are using persuasive decisions outside of the 11th Circuit, I was wrong because it was the Fifth Circuit back then. So in 1961, the Fifth Circuit is Florida. It is still a binding decision. Let's see here. In this circuit, successive motions for summary judgment are disfavored. That's Westlaw. I mean, it's not published. You see this? Tibbetts Lumber, when it's like a Westlaw, it cites the WL or Lexus. It has numbers after it. It's just, it can be persuasive only if the court holds it persuasive. But for you and me, it doesn't count. It's non-binding. Don't use it as a reference. Unless you want to be made fun of. In this circuit, successive motions for summary judgment are disfavored. Other federal courts routinely prohibit successive summary judgment motions and provide litigants with one attempt at summary judgment. And while successive motions for summary judgment are not prohibited by the federal rules or controlling case law, a second motion for summary judgment is not permitted as of right, because the successive motions promote piecemeal adjudication and erode judicial economy. Man, that's some powerful language there. Let's see what the footnote here is. See, Southern District of Florida, Local Rule 56, filing and service of multiple motions for partial summary judgment is prohibited absent prior permission of the court. I bet you this becomes a local rule when this case is over with. See Fernandez v. Bankers, 11th Circuit, 1990, saying that a second motion for summary judgment is not prohibited when the judge allows such a motion. Judge has to allow it. Awadaya v. Ross University School of Medicine, Southern District of Florida, acknowledging the presumption against successive summary judgment motions. The court has the inherent power to maintain control over its docket. My docket, my rules, to ensure effective justice and prevent congestion. Young v. City of Palm Bay, Florida, 11th Circuit, 2004. Because successive motions for summary judgment are disfavored and not allowed as of right, and piecemeal litigation wastes precious judicial resources, the court will exercise its inherent power to strike plaintiffs' motions for summary judgment and supporting memoranda. See Trippo, I guess, Doc 73, 74, 75, 76, 77. Kind of like a saying. All this is just kind of irking the court. It's irking. That's a legalese word. Irking. C. Tipro Consulting LLC v. Cocky, whatever. Middle District of Florida, stating that successive motions for summary judgment are disfavored and allowed only with the court's permission, and striking a plaintiff's successive motion for summary judgment under the court's inherent power. Absent express approval of the court upon a showing of good cause. The parties in this case will be allowed to file a single motion for summary judgment by the dispositive motions deadline. So you guys are going to have to You get one more shot. You get one motion to dismiss. Now, I fully expect there to be the defendants will come out and say, you weren't clear when you said for lack of showing a good cause. Obviously, I have a good cause for doing this because the other side would not talk to me on the phone, email, facsimile machine. Or I don't know. I mean, they're creative. They're creative. We're celebrating the creativity. Let's see here. See, Awadea explained that a good reason is needed for any district court to allow a second summary judgment motion. This is the second one, y'all. Any motion for summary judgment must comply with the word limit and evidentiary requirements set forth in the local rules. See the Northern District of Florida, Local Rule 56.1b, setting an 8,000 word limit for summary judgment motions and requiring the moving party to file any supporting evidence not already in the record. Evidence has to be in the record. It's not evidence. Accordingly, it is ordered 1. Plaintiff's motion for summary judgment and supporting memoranda, documents 73, 74, 75, 76, 77, are stricken. It means the plaintiffs, Hales, their motion for summary judgment and their supporting memoranda is stricken from this record. Prior to the dispositive motions deadline, plaintiff may file one summary judgment motion that addresses defendant's counterclaims and plaintiff's claims if plaintiff believes summary judgment is warranted on his own claims. Plaintiff's motion for summary judgment must comply with the federal rules of civil procedure and the local rules of the Northern District of Florida. 3. Prior to this positive motions deadline, defendants may file one summary judgment motion that addresses plaintiff's claims and defendant's counterclaims if defendants believe summary judgment is warranted on their own counterclaims. Defendant's motion for summary judgment must comply with the federal rules of civil procedure and local rules of the Northern District of Florida. So it sounds like the defense has a chance to do a summary judgment. Plaintiffs do not. 4. No party may file additional motions for summary judgment without leave of the court upon showing of good cause. Never mind. Guessing they have to show good cause to do any motions. I'm not going to stress over this. All I want is that the motion for summary judgment has been struck. So that means we're still going on the way it was. Don't get caught up in the details, what everything else means right now. It's still a lawsuit that needs to be seen in front of a jury. And God bless everybody involved, because I will go back to my original statement that all I wish for is for them to come to an amicable agreement and leave everybody alone. That being said, Godspeed, y'all. Godspeed. Stay safe. Love each other. So much better to love each other.